Good afternoon. My name is Jonathan MacArthur. Some of you may recognize me from 2008 when I ran for a similar position in North Las Vegas. Missed it by 8%. I am the local boy that made good. I'm from Las Vegas and have lived in and outside of North Las Vegas for the past 38 years. I came to Las Vegas Valley when I was 1. I went to Clark High School for high school. I went to UNLV for undergraduate. I didn't have a law school option here locally, so I went back to Virginia for Washington and Lee University, graduated in '99. Between high school and undergraduate, I was also in the Army for the first Gulf War, 108th Intel Battalion, but that is actually out of Korea, not in the Middle East. Honorably discharged. I have worked as a criminal defense attorney for the past 13 years, doing approximately 50 felony trials over that period of time. I'm running for judge in North Las Vegas to introduce sensitivity and a degree of diversity to a bench that has otherwise been rather columnar.
Thank you. And with that, we'll go ahead and move right over to our panel. Once again, starting with Melody.
Good afternoon. Thank you for attending. I guess my first question is going to be to Mr. MacArthur. Can you explain sensitivity on the bench?
Yes, it's become sort of a popular mantra in local electoral politics to sort of affiliate yourself with saying that, you know, I'm going to treat everybody the exact same. And that, I guess, passes superficial muster, but you need to recognize that true justice requires an individual to recognize who are the parties in front of him, what are the facts specific to this instance, and how can I tailor justice or sentencing to have greatest effect here. For example, recognizing that a first-time convicted person, a $500 fine, if he makes $120,000 a year, is not the same as a $500 fine for the same type of individual if they only make $13,000, $14,000 a year and are intermittently employed. Being able to tailor the outcome in order to get the attention and accountability from the people who are in front of you, I think, is more essential. The Veterans Court, as you know it, was established by the Nevada legislature in NRS 176A280 back in 2009. In that, the legislature recognized that Nevada, having Nellis Air Force Base in it, especially the test site, and so many former active service members, had a higher population of veterans than most places. And in appreciation of their service and recognizes of the challenges that they faced, came up with a system by which we can divert veterans, preferably out of the incarceration or conviction area and help preserve their lack of record. The problem with the statute is that it does not go far enough. Most people are not aware that it only applies to individuals who are being adjudicated of a misdemeanor, not a felony. Therefore, if you are charged with a felony and you cannot obtain a misdemeanor adjudication from the district attorney, then you're not eligible. Secondly, you have to show that you either have a drug addiction or PTSD, and lastly, that it would do you some good. We have to give the judges more discretion on when it can be applied and remove the district attorney from the discretionary position of being able to say whether or not an individual qualifies. I took the question to ask about rehabilitation generally and not just in the parlance of drug addiction. I believe that we should regard rehabilitability as a given unless an individual has shown you proof that they are otherwise not amenable to it. In other words, the best way to predict future behavior might be based on past behavior. A person who has no prior criminal conviction probably deserves our best efforts. If we're going to spend our money somewhere to try to stem the problem, we want to start with them, and we don't want to make the check small. However, if that opportunity, if it's an honest opportunity and sincerely engaged in, has not worked, at that point, incarceration becomes a much more likely option. So I think of rehabilitation as something that should be offered to first-timers in most senses, unless they are somehow unqualified because of disturbing violence or particular reckless abandon. I'm going to echo Will's sentiment. Matter of fact, we agree on a lot of things. I hate running against Will because he's a really great guy. Helped get me in the PD's office back in the day. But what I'd add to that is that there's a lot of discretion in law. I mean, there has to be separation of powers. A judge first recognizes that he's not there to legislate, he's not there to execute. But within the boundaries of the confines of the law, there are always gray areas. And the reason I'm echoing what Will said, it's a good example with regard to sentencing or with regard to landlords, being able to give the parties an opportunity to achieve an outcome that's ideal for everyone. Briefly, I was also a pro tem judge up in North Las Vegas before Kalani. I'm no longer there. He is. And I also did it in municipal court. And we had instances where people would come in, and the landlord and the tenants actually got along. It's just the money wasn't being paid. So you pull them aside and you say, hey, can they keep the deposit and give you this amount of money in exchange for this amount of time to move out, and both of them leave happy. That kind of creativity can only benefit.
Mr. MacArthur, please instruct me as to how North Las Vegas handles officer-involved shootings.
Not sufficiently well. Unfortunately, and this isn't to say that I think that there's something wrong with the entire department, but there's a presumption that if there's a shooting that it was somehow compelled, and there's a lack of accountability or transparency on how those are investigated. I think that in order to have the trust of the community, there has to be that transparency. People have to be assured that an unusually high number of fatalities are actually just brought on by an unusually high number of incidents in which the police officer was provoked. But without that review and without some sort of enforcement mechanism, I'm not saying that we should treat police officers like defendants, but still, to just leave it to a system where they're being questioned by the prosecutor, very softball questions, they have a very cordial relationship, working relationship they have every day, doesn't enforce that kind of integrity that I'm talking about. Let me be clear about something. Eric Holder is merely the top law enforcement official of the federal government. His jurisdiction does not extend to state or county government. One of the questions that I was listening to the previous two judges that you were interviewing, or at least Ms. Cellini and the judge, that they didn't note was that justice and district court judges actually have the discretion to order investigation and prosecution where they believe that probable cause exists. It's not simply the opinion of the prosecutor. In this instance, we have a district attorney's office of the county that would act in the same capacity as Eric Holder. Now, if you have a good faith belief that this is criminal conduct, and they are prosecutable under your own statutes in your own jurisdiction, a judge can order that they be investigated and that they be prosecuted. In this instance, that's what I think should have been done. And frequently, even in government, policy is viral, right? An example in 10 seconds. Certain attorneys generals around the country have challenged the Affordable Health Care Act, and then more and more and more and more and did it. The same thing would happen, whether you agree with that issue or not, if judges were to individually and local levels prosecute that fraud. I would say that the perception is based on a stereotype. And stereotypes, of course, are clumsy because people are individuals. However, stereotypes are usually based in something, right? I don't look over my shoulder when I'm at the geriatric home visiting my grandmother. I look over my shoulder when I'm in the dark parking lot on the wrong side of town. So there is a tendency, probably, for prosecutors to be a little tougher on crime and defense attorneys to maybe be a little softer, but it's still highly individual. Me individually, I think that it's important to remember that while the prosecutor wears the white hat, it's easy to sort of affiliate yourself with, the good cause because I'm protecting society. And those arguments are very valid. But usually from the defense side, what you're hearing are about civil liberties and defense of the Bill of Rights and individual liberties as they're applied in the criminal context. Because ultimately, if we don't guarantee those rights to the bottom of our society, then maybe they don't apply to anybody else. And ultimately, that's what we fight for. And I think that judges have a culture in the chamber. They talk to each other. And you need to have people from both sides in order to have an intelligent and meaningful conversation. A man I respect a great deal once told me that if you weren't the man before you got the job, then you're not going to be the man after you got the job. Will said that to me. And I take it with me, even if it came from my opponent. My grandmother exacted a promise from me that I would be a decent and honest attorney, and she's carried it forward to being a judge. She didn't exact a promise me that I would be a judge for the rest of my life. You do the best job you can. Maybe they'll re-elect you. But if they don't, you go back to what you did well.